So that's the so that's the background on the executive order. And now I want to talk to you about, what are your obligations? Because I'm sure many of you are concerned about the impact on your employees, on your labor force. However, but we need to remember that there are concerns that employers need. So that starts with the I-9 verification process. As I'm sure you all know, I-9 is the employment eligibility verification form and supporting documentation that all employers in the United States are required to have all employees who are hired fill out. So an employer must request that employees provide acceptable documents in support of their I-9 form. And employers are required to examine the employee's documentation and keep copies of that documentation with the I-9 form. Now, you're not expected to be, experts in forgery. You're not law enforcement. You're not investigators. So the standard isn't, you have to be 100% correct, and an employer's in trouble if they accept a document that's been forged or is for a different person. Rather, the standard seems it's rather low, and with government oftentimes rather vague. And it says that as employers, we cannot reject reasonably genuine looking documents. Well, what does that mean? Well, there's no good definition for it. So I think a common sense approach is what's appropriate. And that means that if an employee comes to us and, you know, provides a document that on its face looks like it's not genuine, the paper doesn't look correct, it looks like something may have been scratched out and written over it. The name just does not fit at all with the individual who's presenting it, right? Those are things that could give rise to a concern that it's not reasonably genuine. Other than that, you're not expected to determine whether or not somebody forged it, whether they created a new one, or whether they're using somebody else's. Now, when it comes to the I-9 form and the supporting documentation, employers are required to keep a copy of the form and the documents for 3 years or 1 year after the employee is terminated, whichever is later. So that means if you hire somebody and they leave rather soon, or they leave within a year or two, you've got to keep it for that 3-year period. If they stay with you for 3 years and they leave, you've got to keep it now for that extra year for 4 years. It's also important to note that I-9 documents, the form and the supporting documents, have to be available on site where the employees are working, either hard copies or an electronic version, because there are certain government agencies, including DOL, DHS, and DOJ, that's Department of Homeland Security, Department of Labor, and the Department of Justice, who have the authority to come on site and say, we'd like to examine or we'd like to inspect your I-9 documents for your workers. And, just as Department of Labor can come in and say, we'd like to see your time and attendance records and proof of payment for employees, they also have the right to see these documents. They can't take them with them, right? It's not they're not taking them from you, but they have the right to come on and do an inspection, and that is not new. That's been in place probably since the form was adopted, and that's really part of more of the employer compliance end of this. And right now, we're seeing that the government's actions are focused more on the individual who is here, undocumented worker who is here and who there's a concern may have a criminal background or may have done something, somebody who's been identified for detention or deportation. What we're not seeing right now are the general I-9. I'm going to come on and I'm going to come in and I want to see everything, and you're going to get fined if your documents aren't correct. Some of you may recall from 2009 through 2019, right up until just before COVID, there was a lot of enforcement on the federal level by the Department of Labor in that area. Certain industries were being targeted, and their employers were receiving very significant fines and penalties for not having accurate or not even having I-9 documentation at all. That's not what's going on right now, but we would not be surprised to see it eventually evolve back into sort of that type of enforcement as the administration moves along in the next few months and years. Once they've sort of gone through this initial phase of identifying and detaining those individuals who they consider to be dangerous or have been designated for deportation, I would not be surprised and frankly expect that we would see Department of Labor return to the prior enforcement actions that they had done from 2009 through 2019. So what can you do to make sure that you're protecting your business from potential civil fines or criminal penalties related to I-9 compliance? The first is that we need to use reasonable care with respect to collecting these documents. We have to make sure the employee completely fills it out. We have to make sure that the employee provides us documents supporting it. We have to keep copies of those documents. We have to have them available for inspection. And we can't put our head in the sand. And what I mean by that is, while we're not tasked with being law enforcement or investigators, as employers, we do have to make sure that we're making reasonable determinations of the information in front of us. And so what's an example as to how that could come into play? Well, if you have 3 employees who all have the same worker authorization number, social security number, green card number, that's a red flag, right? We can't just say, oh, well, John came in and he gave me the document, he's ready to work. We need to go through and we need to make sure that we don't have employees who have the same documentation and are allegedly the same people. So we should be performing a self-audit annually. And by a self-audit, we go through our I-9 documents for our employees. We make sure that we have the forms filled out. We make sure we have the documentation. If an employee was here on a temporary work authorization, we ask the employee to please provide us with a copy of the updated or renewed documentation. And there's a lot of backlog in that, a lot of delays. It has been for a number of years now. So what would be sufficient is even if the employee is able to provide you with their renewal application to show that they filed it and it's in the pipeline. Because unfortunately, the federal government is very far behind in processing these renewals, even for employees who are here legally. And make sure we have the documents and that we're ready to present them in the event that we have an inspection by Department of Justice or Department of Labor. If we do those small things, we'll have satisfied our obligation as an employer, and we can be relatively confident that even if we've been misled and that some of our employees' documentation isn't accurate or isn't valid or is a forgery, we can have a level of confidence that as employers we will not be held responsible for any fines or penalties. And so that's what sort of my portion of this. That's sort of the background and understanding of the I-9 process. Now I'm going to turn it over to Frank Custodi, my colleague in labor and employment and corporate law, to talk to you about your policy development and training. Thank you, Frank.
Thank you, Brent. Good afternoon, everybody. Still thinking it's the morning. This portion of the presentation is really going to focus on ICE raids and how to prepare from a written policy standpoint, from a training standpoint. So at this point, it's obviously very clear that immigration enforcement and mass deportations are key priorities for the Trump administration. As Brent indicated, ICE is a sub-agency of the Department of Homeland Security tasked with enforcing U.S. immigration laws. One of ICE's tasks is to conduct an enforcement action or a raid without notice to an employer. What is the purpose of a raid? It's to locate, detain, and deport individuals suspected of U.S. immigration law violations. Put this in context, in the first 7 days of the Trump administration, ICE arrested over 5,500 people. This could obviously create a very stressful situation for not only employers, but their employees as well. So it's important as an employer to have a clear written crisis management response plan and training protocol in place to not only comply with the immigration laws, but also to protect your employees. So today I'm going to briefly discuss how to prepare for ICE raids as an employee and as an employer. These points should be included in your written response policy, which we recommend be prepared by counsel. Point number 1, it's crucial to have a designated company representative at each of your locations who is trained on how to interact with ICE agents. This designated individual should be the only person interfacing with the ICE agents. If you have a front desk staff or a greeter, they should be trained to contact the designated company representative when ICE agents are present. Some key points for the designated company representative. Request identification. Verify the agent's credentials, badge number, contact information. Obtain a copy of the ICE agent's warrant. As Damien will discuss, there is a difference between judicial and administrative warrants. Advise the agent that you have a company policy that requires you to contact company leadership and legal counsel if necessary to review the warrant. And most crucially, do not under any circumstances allow a warrantless search. Point 2, understand the scope of the raid. Understand what an ICE agent can and cannot do. ICE agents may enter public areas of the business without permission. What is a public area? Public area is any area that can be accessed by a customer. Lobbies, waiting areas, etc. They're all public areas. If an ICE agent encounters a worker in a public area, the worker does not have any obligation to speak to the ICE agent. If, however, the agent has a valid judicial warrant, the agent has a legal right to enter the non-public areas of the premises and inspect the documentation specified in the warrant, which means as an employer, you need to be organized and know what your documents are and where they are. Make sure you're only providing access to documentation requested in the warrant, which likely will be payroll and time records, I-9 forms, and other employee identification documentation. Note, as an employer, you are permitted to follow the agents to document what they're doing. You could take notes, you could even record them. There's nothing unlawful about that. Third, understand employees' rights and messaging to employees. Employees should be trained on how to interface with ICE agents. You may tell your employees that they can choose whether or not to speak with an ICE agent. Employees should be instructed they can ask to have a lawyer present before speaking with an ICE agent. You should not direct employees to not cooperate with ICE or refuse to answer questions. Employees should be told not to hide or leave the premises if an ICE agent is present. It goes without saying, but as an employer, do not assist employees from hiding from officers or leaving the premises. Employees should be instructed to keep copies of their documents on hand and ensure they're valid. A raid may take hours. If you know any of your employees have specific issues, such as medical or family issues, discuss those issues with the ICE agent and ask for cooperation in accommodating your employees' needs. Lastly, understand that there are post-raid issues. Understand that the investigation does not necessarily end after ICE leaves the premises. Any items that are seized during the raid will be reviewed, and the investigation will likely continue. This process most likely will take months. So in sum, it's important as an employer to be prepared for an ICE raid. These steps will put you in the best position to respond to an ICE raid in quick order. And with that, I will turn it over to Damien, who will speak to you about varying warrants.
Okay, thanks, Brent and Gabby. Welcome, everyone. I will be the last speaker right after lunch. I'm very cognizant of the need to be brief and keep things moving there, which I will be. I have actually, I think, the most complex part of this discussion, so not necessarily the best one to end on when we're trying to be brief and keep everyone awake and moving on through their afternoon. So what we'll do is give you the most simple and best way to deal with the most complex issue. And that is picking up right where Frank left off. There's an ICE raid. They show up at your place. It's just like any other contact with law enforcement. The police officer pulls you over. You're approached by law enforcement on the street, whatever it is. Same principles apply. Utilize common sense. And the best thing you can do, the simplest way to deal with the most complex situation at the time is call your attorney. Call your attorney. So if you have the point person, the designee that Frank and I think Brent also mentioned, they are instructed on what to do. Everything that Brent and Frank just went through, that person should then be instructed to call counsel. Or if that needs to go through you, the owner of the business first, call the owner. It's absolutely critical, not only for dealing with the complexity, but for minimizing the amount of contact that anyone at your operation has beyond which is legally required during an ice rink. So let me explain that. Common sense and the Constitution still apply. Meaning, if someone shows up with a warrant, the warrant is typically, from what we're seeing and hearing, one of two different types of warrants: a judicial warrant or an administrative warrant. With a judicial warrant, which is signed by a judge of competent jurisdiction, will allow a search and seizure. A judicial warrant will allow a search and seizure. An administrative warrant does not trump the Constitution, does not allow the agents to come in and search private areas that Brent mentioned before. How do you know the difference? Well, one is signed by an ICE agent, perhaps an immigration judge. The other is signed by and administered through the power of the court. No one is expecting you to know the difference between the two when there's an ICE agent on your business premises. That's why I say, call an attorney. What do you do in the meantime? Okay, ICE agent shows up, says he has a warrant, says he's there to execute that warrant, whether it be an arrest warrant or a search warrant. As Frank mentioned, ask for a copy of the warrant. Ask for a copy of the warrant while they are outside the premises. Let me repeat that. Ask for a copy of the warrant, the authority by which they are there outside the premises. Agents and law enforcement in general are allowed to use tactics such as, hey, I'm here from ICE. Can I come in and ask you a few questions? Hey, I'm here from ICE. Can I come in and show you the warrant? You do not have to do that. You can say, open the door a crack. Can I see the warrant? Thank you very much. Can you slip it under the door? I'll come out and I'll greet you. Happy to comply and work with you and do what I need to do as required under the law. But until you've confirmed that they're there to execute a warrant, any steps that you take that could be construed as opening the door into the premises or allowing agents in runs the risk that they can execute a warrant or execute a search without a warrant. They very well may have that authority. But again, what they're there to do and what authority they have when they arrive there, you should leave to your counsel to help you figure out. What about the circumstance, you might ask, where you're just not there or things go awry and there's not this streamlined chain of communication from a point person to the owner to the attorney? Well, as Frank mentioned, if they're on the premises and they've already begun to execute whatever it is they're there to do not interfere in a way where you become part of the story. We never want that. And we always reiterate that. You don't want to be part of the story. They have the lawful authority to be on the premises, whether it be in a public place or a private place, as Brent described before. The difference between the two, well, then you can't interfere or try to obstruct their ability to do their job. That gives rise to another circumstance that you don't want to be part of. As Frank mentioned, you can advise your employees appropriately, meaning if they're approached, they can ask, am I free to leave? But you don't want to stand in the way and be human shield between them and anyone else. If they are lawfully on the premises and they're there to execute a warrant and do their job, you're going to let them do that. And the best way you can protect yourself and the business is make sure that everything else that should be in order is in order. Agents are permitted to take action to deal with regulatory violations, licensing violations, even criminal violations that they observe when they are lawfully on premises. Meaning, if they have a right to be there via a valid search warrant and they happen to observe something else that has nothing to do with that search warrant, well, they can take action or at least report back and take action at a later time. So make sure your house is in order, because this is another way in which the government has announced, hey, we're coming to take a look. So with that advance warning, you want to do your due diligence and make sure that everything is where it's supposed to be when it's supposed to be there. I mentioned the two types of warrants. Another sort of technical component of this is they may show up with a subpoena. There's a difference between a subpoena and a warrant. Most of you, having run successful businesses for a long time, have received a subpoena of some kind, even if it's just a request for information regarding maybe a slip and fall that happened on your property. Difference between the two, the subpoena asks for information to be produced at a later time. It's not a warrant that someone is executing to get on your premises or seize information or execute an arrest at that time. Once again, easy solution to what might be a little bit of a complex issue: call your attorney once you have the document. Whether or not these ICE raids are going to happen, one thing is for sure: if in fact you're unfortunately the subject of one, or you happen to be around when one is executed, it's not going to be at an opportune time for you. There is no opportune time for them. But it's important to remember that if they come, they're going to come when they believe the people or the issues or the evidence that they're looking to seize or talk to or arrest will be there, right? That it'll be present. The person will be present that they're there to arrest. The evidence or the documents, someone will be there to show them what they've come to see at the time that they're coming. So it's going to be around business hours. May even be late in the day or late in the night. That's when we do most of our business. That's why we are concierge counsel. We are here on call, and if you have another attorney, they should be available and on call to you, because typically these things don't happen from 9 a.m. to 5 p.m. Monday through Friday. I think the best thing I can leave you with is remember the Constitution applies. Remember to use common sense on any encounter that you have. Be respectful. Don't become part of the story, and call your attorney no matter what time of day or hour it is.
Thank you, Damien. If anyone has questions, you can submit them in the Q&A, or you can submit them on our chat and our attorneys will answer. So we'll give you a couple minutes to do that. We have our first question. If an employee voluntarily provides unauthorized information during a raid, what is the likely liability that the business may be subject to? Brent, do you want to take that one?
I think it would be the same whether it's a raid or otherwise. I mean, if you don't, as an employer, do what you're required to do under the law in terms of verifying the legality of the employee you're hiring, it's no different whether it's a raid or otherwise. The employer can be penalized, in accord with the immigration laws.
And once you voluntarily turn over documents or information to an investigator, if it's at an administrative level or law enforcement, it was a voluntary action, and so it's not going to be, those are certainly materials that are going to be considered in any enforcement or regulatory action. That's why, it's important, as both Frank and Damien said, to make sure that our employees are trained on, most importantly, what not to do, what not to say, and what not to share, and that there only be, our key lead person who's going to be authorized to act and speak on behalf of the company.
Yeah, and I'll just add to that. I agree with both Frank and Brent. If your question is more along the lines where an employee doesn't follow an internal policy or procedure about what's to be done in a certain situation like this, right? Where you've told them, don't speak, let us know what's going on, report it to the designee, to the owner, to the attorney. If they break that protocol, unfortunately, you're stuck with that. The response that they give is, or the information they provide is the information they provide. So as Brent mentioned, the best thing to do is put these protocols in place, train, make sure everybody knows them, and then you have to, trust in your staff and your management that they're going to follow what they've been trained to do.
Thank you. We have another question. For hotels where the doors are open 24 hours, how do we see the warrant before they enter?
Perhaps I can take that. So again, if the area that they're entering is a public area, which includes a hotel lobby or parking lot, and then they seek to execute on the warrant, the difference would be if you have areas where the public is not typically allowed or prohibited. If there's a kitchen, the restaurant in the hotel, if there's a back room for staff where all your back office operations occur, certainly the hotel rooms themselves, those are areas where you would need a warrant to enter. And that's why it becomes critical that if they're entering with something known as an administrative warrant, as opposed to a search warrant, you flag that for your attorney and have them deal with it at the appropriate time. Okay, what is the purview that you're here to execute this warrant? And if they're there with an administrative warrant and they're in a public area, they can execute it. It takes a little more, takes the judicial warrant if they want to try to execute the warrant in an area where you have a heightened expectation of privacy, like a hotel room. But if they do have a judicial warrant, and that warrant states they're there to go to hotel room 1313, they're going to be permitted to do that. It's the assessment of what they're there to do and the authority by which they're there to do it that's critical. So obviously you're not going to be at the front door or the revolving door at the hotel and stopping everybody on the way in. That's not how we operate hotels or really any other establishment in the US. But if you're able to interact with them, and if you can have that conversation or your manager can have that conversation because they've been trained on what to do, that's the time to do it, to then find out what they have, the authority that they have to be there and deal with it at that time. If they go, completely roughshod and just plow in beyond the scope of their authority, well, unfortunately, we can't do anything about that. You can't do anything about something that's totally unexpected and outside the bounds of the law, but you can deal with it later, and you will deal with it later through your counsel. So I hope that's helpful in differentiating between public and private places and why it's critical to have everybody trained to then grab hold of what the authority is and run that up the chain so you can react in the moment.
Thank you. I think that answers a little bit of the next question that we had. So it said, if I arise without a warrant or with the wrong kind of warrant, but still demands entry, how should businesses legally respond? So I think that answered that one. But the other thing is, how should companies handle remote hires when, for example, they filled out an application online and the manager in particular didn't get to see the documents in person, per se?
Great question. So we're still required to have even fully remote employees, employees who were never going to be at our location. We're still required to maintain all this documentation for them. If you use an HR support company, they likely, have a portal through which it'll be uploaded, and you would be able to save it. If you're just doing it remotely on your own, you would still have them, scan and send them to you. And again, it's the standard is pretty low for employers as far as, a determination as to whether they're fraudulent or not. You just they need to be reasonably genuine. So if you look at it, even if you're looking at an uploaded or scanned copy, and based on what you've seen, you have no reason to believe that it would be false or forged, then that's what your obligation is. And if it ultimately turns out that it was, again, as long as you looked it over, it passed the eye test. You don't have 5 other employees with the same the same work authorization number. I don't foresee you having any issues with respect to a fine or a penalty.
Thank you. I think we have our last question. If you are hosting a private event, there are technically no public spaces. Are you able to say that they cannot enter the premises at that time?
I think it depends on the scope of the warrant.
Yeah.
It would depend on the specificity of the warrant.
Yeah. Go ahead, Brent.
Go ahead, Damien. No, go ahead.
No, I was just going to say, what you deem to be a private event, let's say you're having a private dinner, or the room's been rented out at the restaurant for a private event. You're still welcoming the public into that room. It's still a dining area. Because they've paid, certain members of the public have paid to use that part of the venue that evening. That may be an internal, well, we're restricting it to those folks who paid for admission or have this room reserved or things like that. But that doesn't change the calculus of whether or not that is a public space where the public is being invited. We're talking about areas that you use to operate your business where the public will never be invited. They're not an invitee into your kitchen. They're not an invitee or a guest into your office, wherever your office may be, if it's on premises.
All right, I think that was our last question. Oh, just kidding. Nope, that was it. That was the last question. Thank you so much, everyone, for attending. We will be sending you a link to this recording so you can have it and share it with anyone that you might like. Damien or Brent, anything else to add at the end?
I think that's it. Of course, we're always here to assist you on these issues. As Damien said, we're a full service concierge firm. We understand that you'll be as employers, you could be dealing with these type of issues any day or night, and once you sort of calm down the immediate situation, you really should always seek to speak with counsel. And that's really the safest road to take. So certainly we appreciate everybody's attendance and participation today, and we're always here to answer any additional follow-up questions that you may have at a later date.
Always feel free to pick up the phone. If it's after 10 p.m., you call Frank or Brent anytime. No, I'm just kidding. That's what we specialize in. Always feel free to pick up the phone.
Thank you so much, everyone. Have a good day.
Take care.